Lord, 1, 3, 4, and 5 and 6 maybe. Lord.
Which case? Item 4.
4, my lords. Transfer pricing matter.
Ah.
Lord, 1, 3, 4, 5, and 6. My lord. 2 maybe, 2 and 3 maybe 1
Yes.
and this.
No, item 5.
Same thing, my lord. Same.
Yes. Except to everything. Yes. Yes. Which one? WA. Yes. What is that coordinate bin judgment? What happened? It would be the end of. No, Mr. But the issue is covered by this. No, no. You tell us the red single digit place blank on Asian Paints. Right? Asian Paints is a judgment by division bench. Then does it not bind us? It has been done. It's a long back. All right. Yes, Mr. Jeevan. All right, we will say. Huh? In this rectification format, in this intra-court appeal, filed under Section 4 of the Karnataka High Court Act 1961, the appellant has assigned the validity of the order dated 10th March 2021, passed by the learned single judge, by which writ petition preferred by the respondent. Respondent has been allowed, and the appellant's hearing have been directed to permit the respondent to file stroke revise the trans-1 TRAN all capitals trans-1 either electronically or manually on or before 10th of March 2021. While allowing the tax giving right to filing of this appeal, briefly stated that the respondent is a registered dealer under the Central Goods and Services Tax Act 2018. The respondent in a writ petition sought a direction to the appellant's hearing to permit it to file TRAN 1 statutory form either electronically or manually, or for revising the form submitted earlier electronically or manually by extending the time limit prescribed under Rule 170 of CGST rules read with Section 140 of the Central Goods and Services Tax Act 2017 in order to carry forward the unauthorized credit of duty to the common portal under the Finance Act 1994, Karnataka Value Added Tax Act 2003. Paragraph. Learned single judge, after hearing the parties while placing reliance by division bench decision of this court, division bench no, by placing plans on judgment in ACR Limited versus Union of India 2020 within bracket 34 GSTL 50 within bracket Karnataka has allowed the writ petition. It is not in dispute that the aforesaid writ petition, that the aforesaid decision of the learned single judge has been upheld by a division bench of this court, by division bench of this court, while judgment passed in WA number 18 of 2020. It is also not in dispute that issue involved in this appeal is also squarely covered by another division bench decision of this court, the Union of India and others versus Messrs. This all is here. 2000, dated 1st of April 21, passed in WA number 461, bar 2020. Therefore, with a view to maintain parity, therefore, for the reasons assigned in the aforesaid judgment as well as with a view to maintain parity, appeal is dismissed.
Current, the Raghavendra here, yes, please.
Yes.
Different officers. That reassessment powers can be exercised only by the same officer of the cannot be on this matters, the notice has been issued when the litigation begins of the ethics department. Precisely the issue in India case, the litigation issued the notice. What those notices, and said those notices are not in its law. And other decisions of their before the judge. Investigations the canon India procedure, but does not give any but this is not repeated. Because it simply says the canon India decision relates to confiscation. Why not the decision was not related to confiscation, it was an exemption notification.
You have, see, Mr. One thing you would like to point out that you have taken a ground in the writ appeal, that you have challenged the virus of the notification also. So the virus of the notification, right?
Yes.
That issue has not been adverted to.
Yes. That coming to that.
So what is the remedy? 82 Supreme Court. If a ground raised has not been adverted to, what is your remedy in law? No, Supreme Court says that you have to file a review. I mean, of course, you can argue the case independent of this. You will not. Yes.
One issue is addressed. Two issues is not addressed.
So then, the Supreme Court says your remedy is to file a review. 82 Supreme Court. A.R. Ansule's case, you know that.
Yes, sir, I'm already given a
No, you see that decision first. We will take it up whenever. What is your remedy? Learned senior counsel for the appellant submits that the appellant has raised the issue of the virus of the notification, which has not been adverted to by learned single judge. Paragraph in view of opposite submission when a query was put to learned senior counsel for the petitioner as to the remedy available to the petitioner in law, he prays for a short accommodation to enable him to examine the opposite aspect. When do you want this? Every day is convenient. You tell us. You have to tell. Next week. Next week is what? 14th? Monday? 14th? Copy, please. You please tell us what is your remedy, then we go ahead. We will hear it. No problem. Yes. We are not issuing notice. Please understand. We have asked him a question. What is his remedy? He is seeking time. He wants to see A.R. Antulya's case. Let him see.
Number 8, Sri Arun Ji, government advocate.
Yes, Mr. What happened? Huh? Child custody. Go. This is what happens in all matrimonial disputes, which we are wherein habeas corpus is filed. This is what I mean. This is the case, no? That's why you are required to come to the High Court. What else? You can't direct right away. We will have to issue notice. That's what we are doing. Issue notice. Notice on behalf of 1 to 3 is accepted by learned SPP. Issue emergent notice to respond number 4. Just on 23rd February, 24th February. Huh? Where? No, so notice has to be served. Can you do? Will you take hand summons? No. The Kerala is fine, but who will serve the respondents? It is not definitely our duty. So we will not leave the court and serve them. What? Do you understand, Mr. Counsel? That shorter date is fine, but you are not willing to take out hand summons. How do we serve? Then that's so simple, no? Correct. Counsel for the petitioner undertakes to take out hand summons for service of notice to respond number 4 and to file an acknowledgement on or before name date of it. When do you want? Tell us. Before that, you will serve on list on 18th of February 2022. Issue emergent notice in addition. Yes.
Number 9, Sri Muhammad Tahir, Sri R.P. Somsekhaya, Sri D.M. Manjunath.
Hey, mister, you have the email address? The registered post as well as by email at the email address of the respondent number 4. Fine. Yes. Who is that? Who is that? Respond number 3. The right counsel for the petitioner submits that the respondent number 3 died as a bachelor and his brothers and sisters are already on record as legal representatives. He therefore seeks leave of the court to delete the name of respondent number 3 from the cause statute. Let necessary amendment be carried out within 1 week and amended cause statute be filed within a week. Right?
Number 10, Nikhil Sudhinarayan, Nikhil Prasad, K.R. Pachural.
Here for first respondent, my lord.
Yes. All right. Mark the presence undertakes to carry out comply with office objections within 1 week. This thereafter. Unit counsel for the petitioner has liberty to serve the standing counsel for KIDC.
Number 11, Sri Arthur yesterday.
I'm for the
Yes,
petition. A week's time may be held.
Each time.
Member 12, Sri Rajaram, yes, government educate.
You are for the petitioner. He is praying you. That's all right. Yes.
Number 13, Sri K. Naresh Santosh, government advocate. Number 14, Sri Mahesh, yes. Lakshmi K. 15, Sri Paras Pandey.
Mask of no relaxation from wearing the mask.
Ready to argue, madam.
Ready to argue means what?
Lord, I have made my submission,
Hmm.
but subject to what the lordship opined.
Hmm.
Is there an intra-court appeal filed under chapter 6A of the High Court rules that with section 4? When I have a challenge in order and judgment passed by a single judge of this honorable court, in my petition filed under section 24, my petition was dismissed. That I have in my written note and along with my memorandum produced three judgments. Five-judge bench decision of this honorable court in 2005. The three-judge bench of the Kerala High Court on the exact point, and a two-judge bench of this honorable court, which would, if I am permitted to argue with your lordship, what I will be able to, I will try and convince the lordship that the argument is maintainable.
Have you gone through the office objection?
I have made a note of
What is it?
the objection says how this appeal is maintainable under section 4 of the High Court of Karnataka.
Right. There must be how means there are followed by some reason, right?
Not, the reason was not given, but reading one of the judgments.
Please read. You should have read it. Please read it if you are not ready.
Can you pass it over? I'm ready to argue it. I will read it right away.
Ready to argue means what? You are ready to argue. Finally, you should be given certified copy right now. See, wait. When the matter is listed on the question of maintainability, you have to first satisfy. Then we will issue notice. What is ready to argue means what?
I'm ready to make submissions on maintainability.
That's it.
I'm sorry.
So go through. Please go through the office note. Then perhaps you will be in a better position to address us. Please see what it says.
Number 16, Sri Suraj Nayak, Director City, Government Education, Sri N.T. Ramesh, Sri Farah Fatima.
Yes. Eight, 5, 9. Amendment regulation, right? Fourth Amendment regulation.
Yes. Now, under this was made in 2015. The criteria for grant of eligibility will be assessment of merit in the qualifying examination. The quantity of these regulations will be particularly attempted to report new examination which is needed for eligibility of GPS in terms of the welfare regulations. The subject matter of science. And also we want to find that collector deep in so this was an order made by the report to report.
Eight.
Because of people took a view that the seats might be wasted when the absence of candidates who work with leaders. Therefore, ultimately said that persons after exhausting the lead list, if there are seats remaining vacant, to be filled up in works by the audiences based on the educational eligibility provided by the agency. So after this, for the next year again, the authorities sought to impose this order looks towards except before the omnibus before because of annexure to page 79. And as can be noticed to us as paragraph 5 with page 84, they took over the 18 order made by the Assembly. Bottom of the page 84.
Yes.
We have reduced the judgment of orders passed by the High Court, but Karnataka, Gujarat, Rajasthan. In 2018, for annexure D page 88, the regulations were properly amended. Introducing by regulations towards 4A after 1899. The national eligibility agency must be invoked for education. But again, you know, the subject matter challenge. And this one will go to work in terms of annexure E page 97. Yet another order, permitting the qualities to exist findings of the existing need. Unlike the homeopathy, this is homeopathy is a rural based no bigger than 8 years after years of demonstrated that speech go wasted even otherwise. So, having taken one of this position in terms of page 121, the court made a legal order. Quality was to make a decision after exhausting the meat ranking in and the consequence to order was that the was not achieved by the user of India. With regard to this issue order, but with regard to a similar order made in Punjab on the same lines. That work will find at annexure C page 126. Was not followed before the amendment was carried out in the education. When you have the process of time, no response was filed by the Central Council of Homeopathy or by the Union of India. Therefore, did not go into but validated our existence for that year. So this matter, when it came up from other disposal before, this was the report. This was the report of this order of the Supreme Court and this was not saying that it is. They regularized the existence for that year. Thereafter, again it was thought to be imposed, and therefore, yet again another issue was sought by a separate disposition, which will not be found at page 150. After meeting all the parties, to work out the earlier history of this case and proceeded to hold that after exhausting your needs, they will permitted to make a decision. This was again taken up not by the Central Council of Homeopathy before Council that at page 159 annexure M, the The court says you will not interfere with the income of a maid, but however, High Court was reconstructing clear case of marriage. And this was not considered as the regulations are violating it. So the purpose of this order, this was granted to Supreme Court. The division bench took the matter for final disposal, and that order is at page 161. And it's again. Explain the matter in detail. The division bench declared that the regulations were not made in compliance with the requirements of the law and declared it as unenforceable.
Okay.
The court took note of the issue that arises from consideration at page 119. The position in law. I'm not reading all that. In similarity between the main contention, page 193. But the main contention of the Supreme Court is that section 2 of section 20 of the Act specifically mandates that the draft regulations and all subsequent amendments thereof shall be followed by the teachings to all state governments and shall before submitting what taking over all earlier proceedings in the position before. And when the bigger is of these amendments are the right of the above particularly with regard to the non-compliant statute, after this order was made, there has been a change in law. The entire act was repealed, and a new act was substituted in terms of rights of people. New act. Certain kinds of regulations were made, but no regulations have been made. It is also putting section 58 of the act. The word will find that page 249. It says the act is repealed. It is important for my purpose of page 250. Two, notwithstanding the refusal to renewable Federal Council Act, the educational and medicinal standards requirements and requirements of the renewable and the rules of education made thereafter. So the important operation new standards and requirements on the grid of the rules of regulation. Rather than to be repeat that, was not to be continued, one was to discussion. But in so far, I'm concerned that as we declared an analysis to be able to be stated for that. But the authorities are now started imposing the very clear in terms of 151 who are natural testing agencies which conduct a link examination under the Indian Medical Council Act for every job and business. The same brand given same process is supposed to be adopted by the authority, authority, who seek to ignore the judgment and declaration made by the Supreme Court.
Annexed case, page 150. 250.
I need to know this. If you impose, it has been declared as unenforceable. While applying these sources towards the education of indigenous communities. Again, therefore, as the article last year, mistake, this is the basis for taking the so let's do this. Imposition is through a agency order, and you go to NCA 3.4. Ministry of Ayush letter. Reducing to all seats of DNS, you need reducing to all seats of undergraduate So what has been declared as unenforceable? What is possibly being by the Ministry of Finance without even providing for the regulation and agreed by this. So what has happened every year? I have no objection notes for re-ranking the applied and education being granted by the council authorities. I only thought for allowing us not to waste these seats, which is not for 100 and which was only in the existence of our institution. So coming back is also earlier because change the responsibility. We do not be looking for such things in order and this was digital. Therefore, most of the business units were happening on CH-2. Please qualify students of major persons by any other candidate who has not appeared for any examination or not compared to you. At the minimum academic education qualification for EMSS course subject to the regulation. So this is directly work as what considered after hearing all the parties to draft periods continuously. I don't say that is being applied. Why the authorities unmindful of the declaration made by this committee on merits of the case. Therefore, what I'm getting involved.
Yes. Yes. Okay. Yes, please.
Lordship, I appear for respondent number 1, National Commission for Homeopathy, my lord.
Yes, please.
Lordship, my learned friend has been relying upon an earlier act which was called Central Council of Homeopathy Act 1973, my lord.
Yes.
That act has been repealed, my lord, and now National Commission of Homeopathy has taken over that, my lord. In fact, earlier act, my lord, section 20 did not have the provision of prescribing NEET or any other examination. That act only had the provision that they can amend the regulations or they can make the regulations and these kind of provisions.
One minute, we can tell you. What
Got
he
it.
told was that admission is governed by Homeopathy Degree Course Amendment Regulations 2015, not
Yes,
the
my
act. And yes,
My lord, those regulations were declared to be invalid because Honorable Division Bench of Dharwad, my lord bench, said that proper procedure was not followed and those were not in order. Now, my lord, subsequently, National Commission of Homeopathy came into existence and CCH Act perished, my lord. And along with that, the regulations also. My lordship may kindly see page 31 where he has quoted section 14, clause 1 of National Commission of Homeopathy, my lord.
31.
31, my lord, 31.
Yes, please.
Lordship has it.
Yes,
There shall be a uniform national eligibility cum entrance test for admission to the undergraduate in homeopathy in all medical institutions governed under this act. My lord, this is a mandate of this section whereby it has been prescribed that NEET will have to be followed, and there is no provision in the earlier act, my lord, which was section 20. That was the reason, my lord, that regulations had to be framed, which were set aside. But now this act came into existence, and in pursuance thereof, my lord, NEET examination has been advised to be conducted or to be followed by all the candidates who are seeking admission in the medical colleges. Now, my lord, in case my learned friend wants to challenge, he has to challenge the wires of this act or section 14 of this act, my lord, by saying that this is ultra wires or whatever. He has not done that. He is only relying upon the earlier act, which has perished, my lord. Those regulations also cannot be relied upon, because here section 14(1) itself is clearly saying that NEET will have to be followed. Lordship, for a moment, may kindly see page 28 also. For a moment, my lord. Bottom. Shall I read, my lord? Section 20, minimum standards of education in homeopathy. These are the provisions of Central Council of Homeopathy, my lord. Central Council may prescribe the minimum standards of education in homeopathy required for granting recognized medical qualification by universities, boards, or medical institutions in India. Then 2 is copies of the draft regulations and of all subsequent amendments thereof shall be furnished by the Central Council to all state governments, and the Central Council shall, before submitting the regulations or any amendment thereof, as the case may be, to the central government for sanction, take into consideration the comments of any state government received within 3 months from the furnishing of the copy. So earlier act, my lord, did not have that provision whereby it could have prescribed that NEET will have to be followed. That was the reason that regulations were framed, my lord, and those regulations, honorable bench at Dharwad said that proper procedure was not followed. Here, my lord, section 14 says it is the mandate. NEET will have to be followed, my lord, through a testing agency. And my lord, my learned friend has not...
One minute. The
Lordship.
submission is only with regard to the seats which are left after the seats are occupied by the candidates who have qualified in the NEET examination. They are
My
saying
lord,
that they are bound, obviously they are bound. They will have to give admission to the NEET qualified students. There is no dispute. What he says that what happens to the leftover seats?
my lord,
Leftover
for
vacant
that,
seats should be.
I'm sorry, my lord. For
Yes.
that, the percentile then is considerably, my lord, reduced in consultation with the central government, my lord, Ministry of Ayush. And that is how the seats are accommodated. But they say that without qualifying for NEET, earlier now 50% percentile has been, prescribed. Then, my lord, subsequently, in case there are no candidates, then it is reduced, my lord, accordingly. And the candidates are accommodated. Only prescription is, my lord, that they have to appear in the NEET examination. That is the mandate. And this is, my lord, an act of parliament which has been passed and it came into existence, my lord. And then every candidate who is seeking admission to NEET or to medical college, my lord, has to qualify for NEET, my lord.
Yes.
And my respectful submission, my lord, the same issue arose before Delhi High Court also. And Delhi High Court also, division bench of the same view that earlier regulations have perished now along with the act. Now this new act has come into existence and this has to be followed now. And in case they have any objection against that, they should challenge the wires of this act or the provisions of this section 14, my lord. And my learned friend has not done that, my lord. My respectful submission is that earlier act does not play any role for grant of admissions. This is my respectful submission, my lord.
I think anything
Lord,
else? No.
Lordship,
Yes,
I'm great.
what people are you are all right. Yes. Yes, Mr. Ah, ah, yes.
Definitely a uniform natural movement is not becoming true for time. The natural eligibility for members is to engage in the specify by regulations the manner of conducting common functions. Management is not correct in saying that the new act doesn't contain regulations. That is not preventing under the old act. And this is
But what happened to the regulations have not been changed, you said. The regulations under 14 not changed.
therefore, section 59 applies.
Hmm.
It's not just falling back because we are also seeing communication of the argument. There is a reference to the old act regulations that there. That's what I told you at the end. Page 151.
Yes.
Where it says the authority says you follow the 2018 regulations, which you will observe declared as unenforceable. That's what I'm saying. This is something which is being done in the piece of declaration of no way for somebody. Therefore, I'm only seeking for a limited improvement. As was considered as equitable for successive basis of economic growth as not disturbed for the system. So allow my students, even a reducing percentile I have learned that in saying, I'm not saying I will make admission immediately. I'm saying I will exhausting the reduced percentile. If hundreds of them go wait, please allow us to take it up.
Okay.
Ultimately, we work in PMFI. The Supreme Court said it is my fees, and I have the authority to decide how it should be regulated.
Yes.
These regulations must be ensured that there is no exploitation. So, these are going up again.
Ah. Hmm. 220? Yes. Ah. Hmm. 225. Ah, yes, yes. Amendment, yes. Hmm. Oh. Karnataka Private Medical Colleges Association. Hmm. All right. Yes, ma'am. Okay, thank you. Yes. Next.
I'm grateful, Bala. Grateful.
So the same line that pertains to PGM, same issue to arise. Actually, 51 was
Currently, the PN Manmohan, NT Ramesh, government advocate.
Weeks time. Yes, yes. Okay. Oh, wait, yes. My brother senior counsel with 24. Mr. M.R. Naik, senior counsel with or Mr. for a case Suraj Naik, Learned Counsel of the petitioner, appears for two and learned additional government advocate for respond number 3, 4, and then 6 is yes, Mr. Ramesh, learned counsel, Ramesh, learned counsel for respond number 6. Or on the this week, heard on the question of interim release, people voted to respondent number 5. Clear comment. The voted that the clear counsel for the petitioner submitted that in exercise of powers under section 14 within bracket 2 of of the National Commission for Homeopathy Act 2020, the regulations are not being framed. It is further submitted that therefore the regulations framed under the old act, namely Homeopathy Central Council Act 1973, applies to the fact situation of the case in view of section 59 within bracket 2 of the act. It is also submitted that on previous occasions, can you, Mr. Naik, give us the dates on previous occasions? Division benches, various division benches of this court had passed interim orders on 11/10/2018 in WP number 41486/534/2018, as well as on as well as order dated, no, orders dated so and so 20th September 2019, passed in WP number 41486/534/2018, and and an interim order passed on 26/2/2021 in WP number in WP number 100652/21. It is also pointed out that all the aforesaid interim orders were affirmed by the Supreme Court. Full stop. It is also urged that a division bench of this court in WP number division bench of this court while order was judgment dated 31st of August 2021, passed in WP number 100650/21, has held that the amended regulations gazetted on 14/12/2018 and 19/6/2019 are have been set aside. Full stop. It is pointed out that in contravention of the order passed by the division bench, Ministry of Ayush has issued a communication dated executive order dated 30th March 2021, and is trying to, by which it is directed to fill up the seats in accordance with 2018 regulations, which have been held by a division bench of this court to be not applicable. It is further submitted that the petitioners are ready and willing to give admission to all NEET qualified students. However, it is urged that they be permitted, that the petitioners be permitted to make admission for homeopathy undergraduate course for the academic session 2021-2012, which remain unfilled after all NEET qualified students have been admitted to the aforesaid course. On the other hand, the counsel for respondent number 1 submitted that the learned counsel for respondent number 1 submitted that the old act, along with its regulations, have no application, is not enforceable now, and therefore the petitioners were required to challenge section 14 within bracket 1 of the required to challenge the validity of section 14 within bracket 1 of the act, which provides for admission to the course through NEET only. Full stop. We have considered the submissions made on both sides and have carried the record. The regulations under section 14 within bracket 2 of the act has not been framed. Therefore, in view of section 59 within bracket 2 of the act, the regulations framed under the 1973 act apply. Full stop. A division bench of this court with WP number so and so, WP number 100650/2021, by a judgment dated 31st August 2021, has held that the amended regulations, which were gazetted on 14/12/2018 and 19/6/2019, are not applicable to the petitioners. Full stop. The being framed you delete, not be framed. 59. 2000, you said division bench of the court students. Full stop. In the aforesaid petition, the petitioners are the parties. Full stop. Therefore, the aforesaid judgment is applicable to their case. However, the Ministry of Ayush has issued the improved communication dated 30th March 2021, by which the regulations to the undergraduate Ayurveda, Siddha, Unani, and homeopathic courses is directed to be made through NEET UG 2021 as per the provisions of Indian Medical Central Council CH-2 Amendment Regulations 2018 and homeopathic degree course regulations and so and so. The aforesaid executive order issued by the Ministry of Ayush is prima facie in violation of the directions issued by division bench of this court in WP number 100650/2021. Full stop. Therefore, the aforesaid 2015 regulations applied by virtue of section 59 within bracket 2 of the right. This will earlier sentence delete fulfill, not do not. So then it is therefore directed, full stop, taking into account the orders passed by interim orders passed by this court dated so and so, so and so, so and so, right? For the aforementioned reasons, as well as for taking into account the orders dated, all the three orders which have been upheld by the Supreme Court, and a comma, and with a view to maintain parity, it is directed that the petitioner institutions shall be permitted to make admissions for homeopathic undergraduate courses for the academic session 2021-2022, which remain until after all NEET qualified candidates have been have made their choices by any other candidate by another any candidate subject to result of the rate petition. Repeat read with section 26, wherever it has come, right? You say not affirm, not interfered by the Supreme Court. In 51, it will be PG admission, right? All right. You are fine. What is it? Yes, Mr. Suffering from. We will. That's the problem in thing, no. Video conferencing, that's the problem. We probably could not make ourselves clear to the council. He was not understanding. To the petition would have been dismissed. Registered medical practitioner, you have seen. For 21st, learned counsel for the petitioner. Mark this Sarthi HM learned counsel for the petitioner. Learned edition at government advocate for 3 and 4. Mr. N.K. Ramesh, learned counsel for the 105. Heard on the question of admission. Heard on the question of admission has been included. Issue notice to unserved respondents. Heard on the question of interim learned full stop. Taking into account the fact of full stop. The petition heard learned counsel. The petitioner line below. The petitioner is only in service medical officer who has qualified in post, who is declared to be qualified in postgraduate NEET medical examination under the category of candidates belonging to boards and corporations. Full stop. The petitioner suffered from COVID. Petitioner suffered from COVID on 7th January 2022 and therefore could not upload the documents till 21st January 2022. Full stop. The medical certificate furnished by the petitioner discloses that he was discharged from the hospital on 23rd January 2022. Full stop. Therefore, full stop. It is at this stage, learning council. What is the next stage, Mr. Next council? Huh? Fifth. It will start means 6th of February. Learned council for the N.K. Ramesh, learned council for the Karnataka Examination Authority submits that the second round of counseling shall commence from 6th of February. Has commenced from Sunday, 6th of February. In view of aforesaid submission, it is directed that the petitioner shall be permitted to upload the documents for the second round of counseling as well as to indicate his preference for the what option and to submit his option entries as per his eligibility, uh, right? Subject to subject to petitioner fulfilling all other eligibility conditions. List after 2 weeks. Liberty to upload or to submit the documents in person. Yeah, but the other person may not be all right. You are all right. Huh? Why you should take risk? Huh? Yes. Yes. Next.
Number 19. That's month.
Please, my lords, appearing for the petitioner in this matter.
Yes, ma'am.
My lords, may I kindly seek 2 weeks' time to comply with all the office objections, my lords. Obliged.
Yes.
Number 20, government education.
I appear for the petitioner, my lord. Respondent, sir. I'm sorry, my lord. For the respondent, there is a delay in filing the petition by the government, my lord.
19 is something. 19 is huh? 19. Sir, 19 is oh, all right. 20. Yes.
20.
I appear for the respondent, my lord.
So,
Respondent, my lord.
yes. What do you say with regard to delay?
My lord, I'll file an objection or not my grant about it. It's not a small delay, my lord. If it was within 100 days, I should have opposed it. Without any opposition, I should have said it may be condoned because more than 372 days. Not my grant about 3 weeks time, my lord, file an objection, my lord.
The council for respondent. Respondent is granted how much time?
3 weeks, my lord.
3 weeks time to enable him to file objections to IA 1 of 21.
Much obliged.
Number 21. CSP total. The KB Prasanna.
Yes.
I am appearing for the petitioner in this case, my lord.
Yes.
My lord, the petition is prepared by the legal heir of the guarantor, my lord, who was suffered by the impugned order passed by the appellate tribunal. My lord, may I audible, my lord?
You are a young man, you should appear, you should have come to the court, right? Huh? All
my
senior
lord,
counsels are here, why should you appear? So,
my lord, I am
who
out
appears?
of station. My lord, I am out of station. my
CSP
lord.
total. KB Prasanna.
May I request, may kindly have it on day after tomorrow, my lord. I will come physically, my lord. Right now, I am out of station.
Adjournment list day after tomorrow. Yes.
Number 22. Sri Jaisima KP. Srimati Lata Shetty, government advocate. Sri V. Raghunath. Sri K. H. Jagdish. Sri Mujiredi.
Appear for petition, my lordship.
Yes.
My lordship, the respondent number 8 to 9, 11, the copies are not supplied me, my lordship. Regarding IA, that is office objection, my lordship.
Government client. There's a survey report directed for this one. Survey is given report. There's a report given. There was information that we have removed the enforcement. There's a report by the form.
Yes, Mr. What do you say on merit?
2 days. 2 days to deposit. Last one chance. They have heard substantial.
My lordship,
Selective hearing.
the copies are not supplied, my lordship.
What supplied? Hey, Mr. You are for the petitioner, right?
Yes, my lordship.
So survey report has been submitted.
Yes.
There was a direction to carry out survey report.
The survey report is not submitted, my lordship.
Survey report is submitted on 16th July. Paragraph 5 and 6, the survey report speaks about some encroachment. What do you have to say on that?
My
Have you
lordship,
cleared that
date
question?
may be- I am physically appearing, my lordship. Kindly date may be
Hey,
fixed.
why you should not appear? That's what we
My
are
lordship,
asking.
the office objection ends, I am not appear, my lordship.
Ah, so please appear whenever you want. When do you want?
So any date, my lordship. Short accommodation, my lordship.
10th February. Fine.
Oblige, my lordship. Oblige, my lordship.
Okay, 11th. 11th, Mr.
Any date, my lordship.
Case for adjournment to enable him to appear in person. Mark his position. Mr. Senior Counsel for phone number 8 and 9. List on 11th of April. Yes.
Oblige, my lordship.
23, the 8 point Anand.
Lakshmi Senior is appearing in as for the respondents, Mr. Lakshmi.
And Lakshmi Kumar here appearing for respondent. Lakshmi Kumar.
Yes.
Instead of observing the too many pages and the facts and other cases. After it's fine, I'm not in the shoes, I'm reading the submission, I'm not in the shoes of appellant. Otherwise, I'm not in the shoes of
I have a small request. I am not able to hear. Ask him to speak in the mic, please.
For a limited time, a win-win situation. Neither the government nor the matter would be the $18 after refund of money. I can tell you. It said for a period of 30 days. Up to May, sorry, not really, not very bad. But that time, what happens is, we will be able to determine the final figure will be determined by the government. For any reason, I'm thinking that it's for any reason. There is no amount due to the median. Well, we will not demand the money. Number two, let us assume the situation against the bid. If he demanded, what happens is the amount due to the petitioners now it has been deposited with the Union of India. The day are going to have deposited, that is about 400 days. That's all. The interest will not operate on that account. It is good amount of 21 crores. The interest will not operate. Apart from that, there is the provision is there for 100% penalty. The penalty was also there being said. Yes, we are right now, they are right. That will be the ultimately the court will be. But by maintaining this 45 days, the both parties will be in a political positions. Whatever, let's say, not open too much, I have done this, they have not. This is how I am making it as a preliminary point, not in the truth. They let them maintain all the grounds. The Union of India can also maintain all the grounds. And after May, smart safety, 16, 17, anyway, to stay with them, I can take the order. This is how initially I wanted to place it subject to my lord rules and the this runs about 1,000. It is there are two divergent views so far as the question of law is concerned. I'm not helping. Question of law is concerned. The right has taken one particular of a different answer. In a similar circumstance, Madras has taken the difference. Ultimately, whatever the court takes to do, that will be the We are bound by this order. This up to March 15th, whatever it has been happened now, if it could be deferred and later another, that would be suffice part of not that easy. The benefits are to both of them. The litigation will be reduced even not only today, even for tomorrow, and it is beneficial to both in the sense that they are not entitled for the penalty and the interest is received. And if there is no due, so we are going to pay with whatever the equity, the interest, the court orders, we are going to pay for that. And this was
Yes. Yes, Mr.
Yes, Milad, it was a short question before Milad today. There are two dates Milad may just note down. On 30th November 2019, the officers of the investigating agency come to my office and the threat of arrest recovered 15 crores of rupees on 30th November 2019. Again, Milad, we were summoned to their Hyderabad office on 27th 12, and they closed the gate of the door. 12.7 crores. Totally, they recovered 27.7 crores.
They recovered how much you said?
27.7 crores. At the time of investigation, at the threat of arrest and coercion. And several months passed, we went on asking them what exactly the issue. No show cause is issued till now. We went and asked the department to review the refund, return the money, because nothing is happening. The authorities said it is premature. Investigation is continuing. And therefore, we have filed a petition for honorable single bench. Honorable judge held in this particular case, just 2-3 paragraphs I'll read, Milad. Then Milad will know clearly. If Milad kindly come to the impugned judgment before my lords. If Milad kindly come to very detailed judgment at page number Milad 66 or detailed page 35, page 66 of the appeal memo. That is the impugned judgment. Milad got it?
Yes.
Para 40.
Yes, please.
Far as the aspect as whether amount is paid under the coercion as ascertained by the petitioner, suffice it to say the amounts are paid contemporaneous to the very dates when the investigation was being made and during the time when the petitioner's office of directors were at the place of investigation, which fact is not in dispute. If it is that the petitioner were otherwise regularly filing the returns and paying the taxes as evidence from the table extracted para 18, the dispute, if any, as regards the wrongful availment of input credit as regards certain set of transactions is a matter that was pending investigation. Milad, stopping here, Milad, para 18, if Milad kindly come to just 1 minute. If Milad kindly come to para 18, that would be at page number 45. A table, Milad gone? At page 45, internal page number 14. During this period, Milad, the respondents here are the petition before the single bench. They have paid 1,773 crores. Milad, kindly note. 1,773 crores was the tax paid by us during this period in question. And the department says we have not paid 27 crores. Basic allegation according to the Milad is that we received the delivery. What am I? I'm a Swiggy. I pick up whenever a person wants some eatables, food, etc., they come to my portal and then they say which restaurant they want to pick. The menu is chosen because menu is put in my portal. They choose what they want. And then I send my delivery executive to the the restaurant, pick up and deliver to the customer. And I charge service charges for my portal and for the rendering of this thing. That's all. Normally, my lord, I do this service. I have my own executives. During the holiday time, Sunday night, etc., there is a rush more. Therefore, we want additional executives. Therefore, we engage service on another person. They delivered. And they delivered, my lord, I have given to more than 5 crores of rupees, 5 crores of people delivered during this period. The department case is, I have not received any service from that particular person. Therefore, credit taken was wrong. That is the case. We will come back to the question with the right arm. I mean, I do not know how I can deliver more than 5 crores of deliveries without the executives, the service rendered by the other side. We'll deal. Be that as it may, kindly come back to the page 66. I was reading. But instead of allowing the investigation to proceed to be concluded, I'm reading 66 bottom. It appears that the department has acted in undue haste in so far as to ensure that the taxes were paid during the process of investigation. While considering the time at which the amount was deposited in the cash ledger and the date of deposit, it would indicate the amounts were paid during the times when there was no legal obligation to make payment. Well, I may kindly come to the next page for the benefit of the time I will. Page 37, page 66, bottom. The manner in which investigation was carried out in the late hours of the night and the early hours of the morning, with the physical closing of the gates during the investigation, would reasonably create an apprehension in the mind of any person, including the persons of the standing of the directors of the associate company and its officers. The fear of police powers are such that would shake a man irrespective of their society. It must be noted that even to section 132(1)(b), etc., the wrongful amount of input or credit is an offense under the punishment. In the context of the facts are made out, the payment cannot be said to have been made voluntarily because the department case was made voluntarily. And there is a specific finding by the learned single judge. And what he did say is that if that is the position, there is a decided case of make my trip in Delhi High Court. Identical situation where and the department acquires and collected about 75 crores during the investigation. And the Honorable Delhi High Court heard the matter in great detail. I had the privilege of addressing before the Delhi High Court also. And the court said, this amount of collection of money during the investigation under threat of arrests and coercion is bad. You follow the law procedure. If the 27 crores were paid, I'll be willing to pay, no difficulty. But you can't, an investigating officer cannot become a judge. And he cannot simply say that I am satisfied, pay that amount immediately, otherwise I'm going to arrest. This cannot happen. The rule of law is what I am asking for. All the single judge, all this, the judgment said was, following the Delhi High Court judgment, and the court ordered the refund. Revenue went on appeal to the Supreme Court. I argued before the Supreme Court also. Supreme Court dismissed the appeal, saying that this is not the way to conduct their business. And therefore, this honorable court has held that this amount, you consider the refund application. All they said was consider the refund applications. What I am pained, as shocking before is, while they filed an appeal before my lords, an appeal is pending before my lord admission because the judgment was dated 15th of the judgment is dated 14/9/21. Within 1 month, they asked me to process the refund claims. Nothing happened. And they filed an appeal here. In the meantime, the officer concerned issues a notice under section 54(11). I placed before the last time I placed before I suppose the courtmaster can give you the papers, the memo of production of documents I filed on 7/1/2022, about 4 or 5 pages. What the office, I'm sorry, got it? No. It will be totally, number of pages will be 7. filed by the respondents, not by the petition, appellants. Very small. At the end of it, my lord, appeal 1274.
On which date, sir?
On 7/7/1/2020, 7th January. Very thin sheet of papers, only very small. If it is not there, Milan, doesn't matter. I will
Yes.
just, shall we share this, share the screen, Milan, if we can, if you don't mind, I can share the screen. Ravi, can you do it?
We'll get it.
Will. No, by the time the screen takes place, Milan, I will only submit one thing. What happened was, on 7th December, the Commissioner of Commercial Taxes issues a letter to me under 5411 of the GST Act, CGST Act. He is withholding the refund. Milord, I think, and I think I am right. If anybody in this world who can stay the judgment of the single judge is my lord only, nobody else. I don't know anybody else can, any authority can say, I will, in spite of the judgment of the High Court, when matter is pending before my lord, any officer can say that I withhold the refund claim because the following refund. I don't think I have ever heard of it. But this is what and again that letter, my lord, I am before the single judge, I am only bringing to my lord notice, saying that they are invoking section 54.
Yes.
Under section 5411, we have the GST Act before, CGST Act that I can give if you don't have.
Right, so this is not it's the subject matter of another.
Correct. All I am saying, Malad, is this. My prayer before Malad is this.
You are telling us high-handed action in arbitration.
Very high-handed, Malad. It is like iron hand. Whatever it is, I may recover the money under duress, under coercion, under threat of arrest. You have deposited the money. The judge says, onward judge says, return the money. For process the refund claims. 1 month time. Same thing was done Delhi High Court, Supreme Court confirms it. Now they file an appeal before my lord. And in the meantime, they issue a letter saying that I will not. My lord, I am before this. All I am saying, my lord, is this. This particular matter, if my lord want to hear the matter in great detail, I have no difficulty. My prayer, my lord, is this. I am under your umbrella. I am not a fly-by-night operator. I paid 1,700 crores in 3 years' time. And they are talking about 27 crores. My lord, what they are saying, other person is not present. I am saying that that person has cooperated with the department. They send their lawyers. They are in arbitration before me. This honorable court has issued a direction for the arbitration, etc. And still they will say that person is not traceable. But it is basically a matter of convenience. They don't want to collect from the supplier. They want to recover from the person receiving. That is why I challenge section 16(2)(c) of the Act also. Honorable single judge said, this relief I am giving you, therefore I am not getting into the contrary virus. My submission, my lord, is this. This matter may be posted for a hearing anytime if my lord want to hear the matter fully. Or as of now, I am ready. I am fully ready with the matter. If the other side, the revenue, I am ready to argue right now. I am fully ready, my lord. If my lord positive time, if my lord would, etc., he may fix a date. But any interim relief they ask for, etc., should not grant it. Because this is not the time where they somewhere, my lord, they must obey the judgment of this court. They must learn to obey. They just cannot say that whatever it is, whichever judge may pass an order, I will not give the refund. That cannot happen. My lord, simple, straightforward. A due process of law, where there is a short levy or non-levy or non-credit, etc. Section 74 of the CGST Act provides for issue a show cause notice. I have a remedy to reply to show cause notice. And my lord, after that, he can pass an order. When I pass an order, I can file an appeal. Even at the appeal stage, I must deposit 10% of the amount. Now you, of police officer, the investigating officer becomes adjudicating authority at the investigation, pay the amount. All my lord said is, this should stop. Under my lord direction, this court, this state, officers shall not take the law by their own hands. And let them issue show cause whenever they feel like. I have no problem with that. In the meantime, let them process and return the money. If the money is not collected at this point of time, they should not retain the money. And this is what the judge said. And there are several judgments on this subject. Therefore, my submission is, I leave it to you. I am ready to argue right now if they are ready. If they are not ready to argue matter today, some other day, etc., may not become a fixed date. And by which time,
I just what you say.
Difficulty. Oh, you could not, and I don't want to interrupt because when I show is there, it was not correct.
You should have told us, Mr. We you have
Excluding my age, I asked my element also. I asked my element also. If you express ego, not here.
you should have told us.
This is where I am saying.
No, he says that, I mean, if you are ready to argue on matters of merit today, he is ready.
Yes.
If you want some other day, that's what is the submission.
So,
You are ready? Have some.
well, this submission, what I made, hands on the court, I cannot take that. Make a little time. I cannot say I am not ready. If I say I am not ready, I am telling lie. If I say I am 100% ready, that also I am telling lie. Because I will be able to hold, until the matter for about 1 hour or 1 hour, there are still some possibilities left. Those points also I will need.
You tell us date of your.
Well, the difficulty, therefore I submitted, March 15, sorry, no, March 15, till that one, some sort of a protection is given.
No, that is what he is supposing the prayer for interview.
Okay.
He is supposing that prayer, he says, you argue on merits, he is ready to address. Which day? Or you want right now? For which day? Tell us.
Sir, in the sense of my department also, on the department.
No, whatever you want to argue. Day after. We'll take it up earlier.
Okay.
Huh?
Commencing from 40 to 50, we get commencing from 40. 17 or something, 16 or 17 or something, my lord, I'm ready with that matter. Just one protection.
No, 14, 15, 16 any day. Or this week also if you want any day. Tomorrow, day after.
Because tomorrow day after, this total number 6 matters are there. Otherwise, the other is done with the
11th February.
I can take chance on 11th. I can take chance on 11th.
One submission, Marat. because I am not able to hear my learned friend because of the mic system.
He is also not able to hear you. That's
So
it.
Milad, what I will do, Milad, even though I am 70 years old, I will come to Akbar and argue the case.
Of course, 70 is no age. This is senior counsel.
No, difficult. But I think this is important because this is the important matter. Would you honors kindly keep it on 16th or 11th may not be difficult, but 16th or
A small protection, some sort of protection. That's the only.
no, Milad, Milad, I am ready to come on 16th or 17th or 18th, any of these days, etc. I will not take 16th.
16, 17, if they have some difficulty. 16.
16.
Monday, 21st. 21st. At 21st, Mr.
No difficulty. I'll come.
Monday.
No difficulty. 21st Monday, I'll come there.
2020.
I hope not. There is no interim orders and all. No?
The difficulty we are facing as well is not the state government is facing the problem of
You have issued an order that is subject matter of another petition.
not myself. If it is like Indian administrative, I would ask them to withdraw it. It is not Indian doing. Which I have done it, I would ask it. I'm given to understand that it is the state government that issued such an order. That's also legally speaking, it may not stand legal. It is inaccurate. It is inaccurate. But at the same time, my lord, we are also required to protect the officer. The order is wrong.
What is happening? What is happening? Are you being prosecuted for contempt?
Not yet.
What is
not yet.
What is
I am not.
Don't fight. Don't fight.
I am not into the contempt proceedings. I have not done till 25th. I will not.
He is saying he will not initiate any proceeding. Already has done. Thank you.
Will be on the top of the list, Milad. On 21st, will be a top on the list.
21st, please come. Yes.
On the top of the list.
I will. We have taken it from there. Yes. Yes.
For admission number 24, Sri Vivekula, Sri K. Mahadevan.
Appear for R1, madam. First responded by me.
I am for the second respondent.
The petitioner, the second respondent, who was the option purchaser way back in 2003. The appellants are the public financial institutions. Way back in 1982, they are sanctioned loans. The first appellant sanctioned loan 1.25 crore. The second appellant loan 55 crore. The 55 lakh. The third appellant loan 1.33 crore lakh.
1 minute. 1 minute. 1 minute.
Vinayaka, only with you.
29-year-old son of the response appellant and husband of the third respondent died in a motor vehicle accident.
public financial institutions. As of today, the official liquidator can get their security claim for an amount of 12.3 crores regarding these three elements. In fact, in year 2003, the second responding purchased the property in auction for an amount of 1.3. You are appearing, Mr. Krishnamurthy.
But I am appearing for the second respondent, but I have
Ah.
filed the synopsis, Lord. May I request your Lordship to take the synopsis?
Yes, we have seen.
Yes, Lord. And also I have filed a statement of objection also.
Ah.
My Lord, I appear for first respondent, my Lord, official liquidator.
1 minute, 1 minute.
Yes, sir.
Are you able to hear the counsel for appellant? He is arguing.
It's difficult to hear, my Lord. Let him use the mic. Otherwise, I will make.
Not able
Sorry,
to
my
hear
Lord, I should
him.
have come there because of some problem. You have not come.
When will you come?
In any date convenient to your Lordship, my Lord. Today onwards, I have started coming. Otherwise, I my Lord, your short point in this. Not the very short point. But very short point in this, Murad, because
That's fine, but we don't.
please, day after tomorrow, all day.
Day after.
Please.
Krishnamurthy Lawrence, Senior Counsel for phone number 2, pray for a short accommodation this on 9th February 2020. They don't respond, Mr. We are thinking of keeping some mechanism here to give them light electric shocks so that they respond. What you do, you are seeing. They do. He is appearing here. He should accept notice. He doesn't respond. What do we do?
I'll see that set of papers are being placed on them.
Please,
It is wrong. It is wrong.
They don't respond.
It could go against the court.
What is this? You need this thing, him to tell that you have to contend. I mean, what is it? Why shouldn't you? We have told the other day, we have told Mr. Jeevan, I mean, this is the type of assistance if it is offered to us. Then what, I mean, the burden, we understand is on us because we have taken oath to do justice. But every time a judge is elevated, what do you tell us? That we will cooperate fully with the court and extend full cooperation. This is the cooperation. We have told Mr. Jeevan, we really, Mr. Nardun, see the state of affairs. Please, you yourself are witness to this. What to do? Mark the presence. Except notice on behalf of all. Thank you. Yes, next. 25.
I'm appearing for the respondent.
Yes, you appear for.
This is
What
a
has
case,
happened to the process of liquidation?
my lord, in this case, my lord, they are trying to revive the company every time, and I filed a detailed objection. 15 to 16 attempts they have done, my lord, and everything got dismissed. Your lordship will kindly see the objection. Even their objections is closed now. They have not filed it also. It's a frivolous appeal, my lord. It has to be dismissed, my lord. This honorable court has, may I submit, my lord? I'm for the official liquidator, my lord. May I submit, my lord?
We are, nobody is appearing for the appellant, madam. We are trying to certain.
I understand, my lord.
All right, you are ready, very good. But nobody is appearing for the appellant. That's what we are. None appears on behalf of the appellant, market presence for responding official liquidator. None has appeared on behalf of the petitioner on 1/10/2021 also. Appellant, none has appeared on behalf of the appellant on 1/10/21. Today also when the none has appeared, dismissed for want of cause.
I appear for the appellant, my lord. My lord, this is an appeal against the order of the appellate tribunal under PMLA dated 18/7/2018, my lord. Here in the
Yeah, Swaroop.
What happened now?
my lord, the appellate tribunal, my lord, has set aside the order of provisional attachment as well as the confirmatory order of attachment passed by.
So tell us what has happened under SURFACE Act.
My lord, not SURFACE, my lord, the PMLA Act, my lord.
The order of attachment of the property under PMLA Act has been set aside.
Yes,
Are
my
we
lord.
required to explain it to you, Mr.?
I'm sorry, my lord, I didn't
That
hear
means,
it.
no,
I didn't hear
that means you have not read the impugned order. Learned counsel from
My lord,
made
my
by
lord.
learned counsel for the appellant. It is evident that he has not read the
My
impugned
lord,
order.
no, my lord, I'm sorry, I
He
didn't
is
hear.
granted time to go through the impugned order.
My lord, one submission, my lord. I have
10th
read the
of
matter.
February.
My lord, I've
10th
read the
of
matter. I'm sorry, my lord. I'm sorry, I didn't hear. I'm sorry, my profound apologies.
Ah.
I've gone through the matter. I'm fully ready in this matter. My colleague
so
is
what
also
is-
there with it. My lord, the appellate tribunal.
Why
my
it
lord,
has been reduced?
My lord, my lord, the operative part, my lord would find at page 35.
No, we don't want to.
My lord, what has happened, my lord, the appellate tribunal would say.
You are appearing here to assist the court.
My lord, the appellate tribunal would say that we have not been the authority, adjudicating authority and the officer of the enforcement directorate, the appellants herein, have not been able to show that, come to a conclusion that the 70 lakhs which was attached is out of the proceeds of crime. My lord, my submission, my lord, would be, my lord, when there is section 24 of the PMLA Act, which presumes, my lord, that the person is charged in the offense of the PMLA Act, the burden is upon him. Secondly, my lord, there's another observation of the tribunal which would say that there is no mens rea when the offense took place, my lord, that the money was not in the custody of this particular person. My submission, my lord, is under section 2U of the Act. It not only says that you should hold the property and or in possession, even projecting as untainted, my lord, is my lord. Permitted. Oh, obliged, my lord. It's sought for an interim order, my lord, because the 70 lakhs which, my lord, is in the account of the respondent. These are the proceeds of crime, my lord.
2018 appeal.
Yes, my lord. Obliged.
27, the Prakash K. The case Mahadevan.
My lord, appear for appellant.
Prakash K.
Yes, my lord, appear for appellant.
What is happened?
My lord, appear for first respondent.
What document? Who is appearing for the appellant?
Appeal for the appellant. Yes, my lord.
Yes.
My lord, the quarters belonging to this honorable court, the official liquidator, respond number 1 being the custodian of this quarters, my lord, has been registered in the name of
Which quarter belongs to this court?
my lord, the company was liquidated and the official liquidator has been assigned the properties of the quarters, my lord. One of the employee has registered in the name of his minor daughter.
You are challenging the sale deed, validity of the sale deed.
Yes, my lord.
So you have been granted the.
Can you challenge in this proceedings? Is the
No,
question.
no, my lord. The sale deed is not because of the agreement between the private parties, my lord. The property belonging to the official liquidator has been wrongly registered in the name of a minor girl on the basis of forged document produced by one of the employees, my lord. 17 years old minor girl was given documents stating that she was an employee of a central government company. His father's name was Veerbhadra Shetty, my lord. He has taken the quarters as per the order of this honorable court. And another 2 quarters in the name of his daughter and son also he has registered. It has come to the knowledge of us only recently, my lord,
That's why we are pointing out before this honorable court.
Fine.
If fraud has been played by one of the employees, impugned order is at page number 13, my lord. Impugned order.
Yes, please. Yes.
Lord, may I take your lordship to page number 23, my lord. 23 of the impugned order.
Read.
Ink page number 23, my lord.
Yes.
Lord, the second para, my lord. Second para. Thereafter, this court, by an order dated 21st February 2018, had directed the official liquidator to carry out spot inspection by obtaining signatures of the Mazar witnesses for the same, and the same also be brought on record. Thereafter, the official liquidator filed a memo dated 20th March 2018 and stated that official liquidator carried out spot inspection on 24/2/2018 and noticed that a disputed plat, quarters number 105 bar A, is mostly a vacant land except a small temple structure necessary measuring approximately 5 feet into 4 feet into 6. There were no signs of previous structures found on the site to prove the existence of said quarters. The immediate neighbors of the subject quarters also reported that site has been vacant all along and no quarters stood constructed on the site. Panchanama spot inspection memo signed by the immediate neighbors at Annexure A. It is also noted that stated on perusal of the sale deed with respect to the immediate neighbors in quarters number 106A, it is noticed that the western side border is vacant land, so-called quarters number 105A. The father of respondent number 2, namely Shri Veerbhadra Shetty, himself is a witness. A copy of the sale deed dated 28 January 2005 with respect to quarters number 106A is furnished by the vendee himself, and a color printout of the Google Earth image of the year 2002 and 2006 are also produced at Annexure B, C1 and C2, and also stated that a small temple structure measuring approximately 5 into 4 into 6 has been erected. The sale deed with respect to the subject site was executed for a consideration of rupees 12,500. The report of the official liquidator itself says, my lord, it is a vacant plat. There cannot be any
Let him read
quarters.
the next page, next para, my lord.
In view of the two reports filed by the official liquidator, one report depicts that a house, so quarters number 105A was existing, and appointment letter produced by the respondent number 1 prima facie, there was a house. Based on the prima facie document, this court directed the official liquidator to execute the sale deed after the present application is filed by the so-called association to cancel the sale deed. Report is entirely different from the original report. There is no consistency in the stand taken by the official liquidator. My lord, the second report is produced by the official liquidator after direction by this honorable court to conduct spot inspection, my lord. The earlier report filed with the official liquidator is based on the forged documents produced by respondent number 2, my lord. A 17 years old minor girl was given an appointment order, forged appointment order by her father, my lord, by name Veerbhadra Shetty. He has taken 3 quarters for his family by giving all forged and fabricated documents. Based on that, official liquidator filed the first report, which this honorable court did not agree, and directed the official liquidator to visit the spot and conduct a spot inspection report. Then the second report is filed, my lord. By ignoring all these things, saying that I am trying to usurp this property, my lord. This is the property of this honorable court. I don't want this property, my lord. It is a children playground, and which the respondent number 2 has falsely stated as a quarters and taken the sale deed, my lord. The order of this honorable court is only for 300 quarters, not for the playground, my lord, children playground. Ignoring all these vital facts, my lord, my company application is dismissed, stating that I am trying to usurp this property, my lord. Yes, my lord.
Yes. Hey, don't read, you have to tell us what is it. You must have read it at home, right?
Regarding the one of my days of the appeal, and we questioning the same way today, after a period of 14 years. That my lord, that is a matter of given, residential one. I'm not entitled. I want to-
Yes, that's all.
Much obliged. What date given, man?
Number 28.
My lords, item 28, I appear for the appellant. My lords, just a brief background, my lords, given the subsequent developments which have taken place after filing of the appeal, this appeal may be disposed of at this stage itself, my lords. My lords, this is an appeal under section 260A of the Income Tax Act, challenging an order dated 3rd July 2019, passed by the Income Tax Appellate Tribunal. My lords, the issue which is impugned in the present appeal is in respect of an addition of rupees 2 crore 36 lakhs made in the course of proceedings under 263 of the Income Tax Act, my lords, revision proceedings. My lords, I'll just outline a few important dates. My lords may, if convenient, my lords may note it down. My lords may then decide the matter at this stage itself, my lords.
This is listed for orders on admission, right?
Yes, my lords, what has happened is, my lords, I'll just point out this. If my lords are inclined to admit, so be it, but I'll just point out that there might not be any need for admission, my lords.
Lord, it has rendered academic, my lord, as at today,
My
my lord.
rendered-
Subsequent proceedings and
That's the
also.
problem with the young people. He believes in telling us a story. We don't have the patience. And what brief facts and what note down.
My lords, what has
been
happened?
rendered academic, right?
Yes, my lords, what has happened is that the 263 issue has gone back to the file of the CIT. This is the consequential assessment. This may also go back, my lords.
Yes, Mr. Arvind, please tell us. He is unable to explain. Yes.
The 263 revision order, my lord, was passed.
Huh.
That was subject matter of appeal before your lordships, my lord, in ITA 400 of 2016, for which, my lord, copy is being placed before your lords.
ITA 400 of
2016.
huh. Yes.
In that, my lords have, my lord, set aside and remanded the matter to the tribunal.
Yes.
My lord, after the remand, my lord, the tribunal by order dated 27/12/2021, my lord, which is placed before your lordships.
Then what?
My lord, upheld the jurisdiction, my lord, as per para 39 of 263. However, my lord, remanded the matter on merits. The assessment order, my lord, subject matter of appeal before your lordships, my lord, is a giving effect to the order which was set aside by your lordships, my lord. In view of that, my lord, the consequential order, my lord, renders, my lord, infructuous and needs to be set aside with liberty to the assessing officer, my lord, to pass a fresh order if need arises, my lord, subject to outcome of the remand order passed by the tribunal.
We are unable to hear you. Huh.
I'm extremely sorry.
So what did you tell us that it was remitted to the AO on merits, right?
My lords, the CIT on merits. It has gone to the commissioner.
On merits, but because this order, assessment order, subject matter, my lord, of appeal before your lordship, my lord, was giving effect to the.
So this was remitted to this thing, Commissioner of Income Tax, 2712. 2712.
Yes, my lords may just have paragraph 40, my lords.
39 and 40.
My lords, around 7 lines from the bottom of the page.
Just a minute. Don't. You had your say, right? We gave you the opportunity. We are now
Great.
trying to understand from Mr. Yes. So Mr. What happened?
But para 39, my lord, in that order.
Simple. So it was remitted, right?
Now, because of this remittance, my lord, assessing officer has to, my lord, subject to the remand order, has to pass a fresh assessment order.
What is what is the order in this appeal?
In this appeal, my lord, 400 ITA 400 order, your lords, my lord's order may kindly be taken, my lords.
Yes.
My lord, in this, my lord, the 263 order, my lord, was under challenge. 263 order, my lord, was upheld by the tribunal, that was under challenge. Your lordships remitted, my lord, that matter to the tribunal. My lords will find that para 12 at page number 9.
Yes.
My lord, the order at 27/12/2021, my lord, is the outcome of a remand order of your lordships, my lord.
27/12/21.
That copy is also available with your lordships. In view of that, my lord, the assessment order impugned in the appeal, my lord, needs to be set aside, my lord, just to pass a fresh order, my lord, after the remand order. In that sense, my lord, it renders academic.
Yes. You can type, madam. Today or tomorrow? Please. We appreciate that. We tell her to yes, the other one. Mr. KVR when it comes to the on the not admission. It is admitted on following substantial questions of law 9.123, right? Yes. Then third, argument third, judgment signed and dictated in separate. This is the order sheet. Then judgment. Take appeal. The section 260 item dash capital A of the Income Tax Act imposed against order dated 3/7/2019 passed by the Income Tax Appellate Tribunal. It is pertinent to note that in ITA number 400 of 2016, disposed by a judgment dated 17 February 2021. Set aside. Quash the matter, quash the order dated 20th January 2016 and remitted the matter for decision afresh to the tribunal in accordance with the observations made in the aforesaid judgment. In pursuance of the aforesaid order of remand, the tribunal has passed an order on 27/12/2021 and has upheld the invocation of power under section has remitted the matter and has remitted the matter to the assessing officer. Full stop. Paragraph. In view of the aforesaid subsequent events, the order, it is not necessary for us to answer the substantial questions of law involved in the appeal. The order of the tribunal, full stop. The order of the tribunal dated 3/7/2019 for the assessment year 2008-2009 is set aside and the matter is remitted to the assessing officer for passing a fresh order in accordance with law. In the result, appeal is disposed.
May make one submission, my lords.
Ah.
Well, other two orders also needs to be set aside, my lord. The annexure came, my lord, at 125.
125 order.
And annexure L, my lord, at 131.
Yes. So and so past. All right. Thank you. Yes.
29, CK Anandrama.
Appeal is admitted for hearing on following substantial questions of law. A and B. Issue notice. No recovery, nothing happens.
The 30.
The litigation begins once an order is passed. You know what to do. We are not. Your appeal has been dismissed. Not compliance with proviso to 43(5) that we will answer. Yes. We have not rejected it. Please understand. So tell us what is the next date in execution procedure? That's nothing. Apprehension is of if you go out, you may fall down. This is also an apprehension, right? Life is full of risks. Next.
30, Siddharth Suman.
Please, my lords, I'm appearing for the appellants in this matter. My lords, we prefer this appeal against the impugned order dated 11/12/2020, which my lords will find at page number 13, my lords. My lords, this appeal has been. My lords, may I kindly seek for a stay in this matter, my lords?
Notice on IA2 of India. Same question, madam, just now you have heard. What is the next date in execution proceeding? Have you received notice?
No, indeed, no, my lords.
No. Be happy. Same thing we told. Just in fine. Thank you.
Obliged.
Continuing B group, number 31, Sri Rajesh Surapine.
I pay for the. My lords, in writ petition number, my lords, 3120 of 2018. My lords, filed by Mr. Brijesh Patil, advocate. His mother is passed away. My lords, he is not before the court today. Lords,
31.1. It is stated at the bar that Mr. Brijesh Patil, learned counsel for the petitioner, has suffered a bereavement. To stop, let the writ petition listed after 2 weeks.
The 32, Sri Taranath Shetty ke. Sri Taranath Shetty. So, number 33, Sri M. Nagarajan, government advocate.
Wait. This is land grabbing. What is it? Order taking cognizance, right? Hot ground.
prior to the amendment. Change the text. Yes. Can we specifically
From 17 matters, 18 matters, these are not at all. The petitioner pays for short adjournment. Just on 15th February.
34, Sri M.H. Rajendra, Sri C.G. Malai, Sri B.S. Guruswamy.
Yes. Why? Huh?
Regarding amendment of the bylaw.
What is the matter?
Directed the petitioner to amend the bylaw. And recently this court code, it is a body association. In the meantime, petitions for filed last week.
What is it? 2019. What is CH-2 2019? What is it? What is it? Seeking a writ of quashing. Ordering. Karnataka for the GST. What is wrong with this direction to amend the bylaw?
We are all the associations that are affiliated with that, we are registered local.
And to hold the elections. The elections have been held, right?
We are established and we are transferred in Karnataka Securities Registration Act. That case is not in the agreement.
You appear for responding.
C.G. Malai,
You take their name also, Mr. You only call.
Appear. Serial number 35, appear for the petitioner, my lord.
34, sir, 34, Sri C.G. Malai. B.S. Guruswamy.
None correspondence. Awaiting appearance of learned counsel for respondent. Hearing of the petition is referred.
Respondent in this case, my lord. Appear for the petitioner, my lord.
Number 35, Sri D.P. Muthana, Sri N.V. Vedmurthy.
Appear for the petitioner, my lord. In this writ.
Both are there. Please.
Both are there.
Yes, my lord. I can argue, my lord.
I am also ready. Ready.
My lord, this
yes.
This writ petition is filed, my lord, challenging the order of learned CGIT, wherein that CGIT has passed the order for reinstatement in the service of the bank, my lord. Here, my lord, in this case, what happened, my lord, that original documents could not be produced because the original documents are misplaced. Bank, with all the efforts and all, they were unable to produce the original documents. Is it audible, my lord?
Yes, yes.
Bank was unable to produce the original documents, my lord. Then an application was filed before the CGIT, my lord, requesting to permit the bank to adduce second evidence. This honorable CGIT has permitted to adduce the second evidence, my lord. After adducing the second evidence, the honorable court has come, CGIT has come to the conclusion that inquiry was conducted, fair and proper inquiry was conducted. And thereafter, my lord, that while giving the findings, my lord, award, my lord, the honorable DRT has said, CGIT has said, my lord, stating that because that inquiry officer, inquiry findings and findings of the inquiry officer and orders of the appellate authority has not been produced, I am unable to judge whether the inquiry has been conducted properly and all these things. This CGIT has passed the order in favor of the petitioner, my lord. Now, that is why, my lord, now, my lord, here I have filed an application for production of the documents. These documents are permitted, my lord. This matter has to go back to the CGIT, my lord. One of the important document is, my lord, that the petitioner has admitted the charge, admitted he has embezzled the bank's funds, my lord, and he has admitted and returned the money. And that means it amounts to the admission of the guilt. Hence, my lord, I have filed the application for production of documents, my lord. Your lordship may kindly, the award passed by the Honorable Tribunal, my lord.
I appear for respondent in this case, my lord. I believe advocate for the petitioner has concluded his arguments.
No, my lord. No, my lord. My lord.
You have not concluded as yet. Yes, please. I guess, yes, Mr. What have you to say? Counsel for respondent.
May I submit, my lord, on behalf of the respondent in this case?
Please.
My lord, admittedly, the entire inquiry has been conducted on the photostat copy of the document. And therefore, the whole
Contents are admitted, Mr. Photocopy. Contents of those documents are not been disputed. All right. Photocopy. So what?
The whole proceeding, right from inception, is absolutely impermissible and illegal, but it is bad in law. In the light of the Allahabad High Court judgment rendered, reported on 25th April 2007, my lord, in the case of
Citation.
Ashok Kumar versus Assistant General Manager, my lord.
Citation.
It reported that the inquiry conducted on the photostat copy of the documents is bad in law. It is not permissible, my lord.
Even
And
if
it is a ban to
contents are,
education.
yes. Anything else?
It's a financial institution, my lord, where they are supposed to maintain all the documents intact. And in this particular case, they say that the documents are not traceable and they are lost and they could not be produced. And therefore, the learned Central Government Industrial Tribunal has come to the right conclusion that on the basis of the sole interested testimony of the bank manager, the punishment imposed is absolutely illegal and not permissible, my lord. I would like to take your lordship's kind attention to page number 19, my lord, wherein during the course of cross-examination of witness, the veracity of these photostat copies was very much disputed. However, while adjudicating the preliminary issue, the documents exhibit M1 to M9 are accepted. The first party workmen not only opted not to adduce rebuttal evidence, that is the ground urged, and while leading evidence before the tribunal in respect of his unemployment and allegation of victimization, he has categorically said that he has not been employed after the punishment was imposed by law.
ಬಿಸಿ ಇದ್ದಾರೆ ಅವನ ಆರ್ಡರ್ ಏನಾಯ್ತು ಅಂತಾರೆ ಬಂದಿದೆ ಅನು ಮಾಡಿದ್ದಾರೆ ಬಟ್ ಅದನ್ನ
the judgment in the para number 8 of the award, my lord. During the inquiry, sole witness examined for the prosecution was then branch manager Kerebilchi branch, and through him 13 documents were marked in evidence. The problem here is to appreciate the report of the inquiry officer. This tribunal is obliged to verify the documents marked during the inquiry. Unfortunately, those documents, or the least certified copy of those documents marked as the BX1 to BX13, are not placed on record, my lord. It is impermissible to record a finding on the inquiry report on the basis of the statement given by the witness before the inquiry officer. in the absence of the documents marked or copies of the documents marked, my lord. Therefore, the whole inception is prejudicial, highly motivated, my lord, and the respondent has been victimized at the hands of the petitioner bank, my lord. Para number 9 also I may be permitted to read, my lord. In view of the above peculiar circumstances, the tribunal is not in a position to endorse the finding of the inquiry officer. The original of the punishment order passed by the disciplinary authority and the order passed by the appellate authority are also not produced. Only photostat copy of both orders are produced. Since I am not able to endorse the correctness of the inquiry report, the orders of the disciplinary authority and the appellate authority, whereby the inquiry report is accepted and acted upon, cannot be upheld as legal, my lord. The further takes into the fold punishment of discharge from service with superannuation benefits imposed on Sri Palakshi by the management of State Bank of Mysore, now State Bank of India, is not legal and not justified, my lord. In this particular case, the respondent alone could not have drawn the amount without the collusion of other people. There will be 5-6 people who in between, who one person will be having the custody of the withdrawal slips, and another person will initial and then send it to the cashing clerk and then to the cash counter. Like this, 4 or 5 people will be there, my lord, in this particular case.
They were all mixed up. Yes.
Repeatedly, my lord, he has remitted the entire amount of 40,000 rupees on 2 occasions. There is no financial loss whatsoever to the bank, my lord. Even assuming for argument's sake that he has withdrawn the amount, he has credited the amount, remitted the back.
It will be a valid defense in criminal law also that 40,000 theft committed, deposited, paid to the owner, no offense. Yes.
Punishment order is too excessive, my lord, disproportionate to the charge leveled against the respondent, my lord. Therefore, the order
misappropriation, in our opinion, of 10 rupees on the part of an employee of the bank is good enough to keep him out of employment. This is what Supreme Court says. Your honesty and integrity is the all right, fine. Yes. What else?
Therefore, the
proportionate punishment is disproportionate.
Industrial Tribunal may kindly append, my lord. In this particular case, respondent has already retired from service on 31/8/2020, my lord. He is no more in service now. Therefore, the award passed by the Central Government Industrial Tribunal to consider the back wages of 75% and within 60 days of the award.
What is the reason? I mean, you know the law that for directing back wages, the court has to assign reasons. What is the reason assigned for 75%? Thank you. Anything else? That's all. Yes, please.
I may be permitted to read the relevant portion of the judgment rendered by the Allahabad High Court, my lord, in a similar case.
No, but you are not telling us the citation. No, that's our predicament. How do we find out that Allahabad High Court judgment? It is not binding on us, number one. Secondly, you have to tell us the citation. How do we get it? You are not here to pass on the judgment to us. We don't have any access to that judgment. How do we know? What are you reading? Citation, please.
Ashok Kumar, son of Balachandra.
Citation of the judgment you are referring to, please.
Where is it? Is it reported or unreported?
It is reported, my lord. It is reported.
Please tell us which journal, AIR, where is it? Where it is reported?
Yes, my lord. It's reported
That we have got.
on 25 April 2007, my lord. Allahabad High Court judgment.
Which journal is it reported, Mr. Counsel?
2007, my lord.
Yes.
I may be permitted to read the relevant portion of the judgment, my lord. With the kind leave of your lordship, I may be permitted to read. Para 31 of the judgment, my lord. I also perused the findings of the disciplinary authority. There is nothing to indicate that the reply submitted with the petitioner against the findings.
At least tell us it is single bench or division bench. Division bench or single bench.
This is a division bench, my lord.
Because you have read do not means means single bench. Or the
Single bench, my
expression,
lord.
see, on single bench decision of another high court, which is not in any case binding on us, and that too without telling us what is the citation. What can we do? We will have to write that you have read para 31 of a single judge of Allahabad High Court of a decision which is not reported. You have not supplied a copy. We can't do it anything about it. Right? Read para 31.
I may be submitted to the judgment copy along with the memo for kind consideration for your lordship, my lord.
Time is up. Yes, whatever, argue whatever you want. Yes.
Inquiry on the photostat copy is completely illegal, my lord. It is not permissible.
That you have
by any stretch of imagination.
Yes, that's all.
My lord,
My lord,
my lord, in regard to my lord, in regard to secondary evidence, my lord, this Honorable Supreme Court in a civil appeal number 13361.
Let him complete, Mr.
Yes.
Yes. Read para 31. Read.
The petitioner bank has not even produced secondary evidence, my lord, in this particular case.
That's it.
Is on that point only, my lord. I might be permitted to read, my lord, for a minute. I have perused the findings of the disciplinary authority. There is nothing to indicate that the reply submitted by the petitioner against the findings of the inquiry officer has been considered and discussed. Proof. Disciplinary authority, while agreeing with the findings of the inquiry officer, need not to record his independent findings on each and every charge, but at the same time cannot escape to deal with the objection of the petitioner against those findings, which is minimum requirement of fairness in decision making. Thus, the findings recorded by the disciplinary authority, in my opinion, appears to be mechanical and without discussing the points raised by the petitioner to in reply submitted by the against the inquiry officer. Therefore, the findings of the disciplinary authority are also vitiated under law, and for the reasons the finding of the appellate, thus the findings of the inquiry officer contained in the inquiry report dated dismissal possible by the disciplinary authority as contained in exterior are absolutely not permissible. And the decision is some photostat copies mele the inquiry cannot be conducted and the punishment cannot be imposed, my lord. When the original documents are not produced. Therefore, the petition is liable to be dismissed, my lord, by imposing exemplary cost, my lord.
How much costs according? What is your rate? Or to the extent of 1,50,000. How much?
Number 22 of the judgment, my lord. Therefore, the photostat copies of the relevant documents could not be relayed and acted upon by the inquiry officer as the photostat copy of the aforesaid documents, in absence of proof, could not be taken in evidence in the eye of law and could not be acted upon by the inquiry officer. And if photostat copy is produced by the inquiry officer is excluded from consideration, there is no other evidence before him in support of the charge to establish the guilt of the petitioner. Thus, in my considered opinion, the findings of the recorded by the inquiry officers in this regard is based on no legal and admissible evidence. Thus, can be said to be without any valid and legal evidence, as such cannot be sustained. The punishment order cannot be sustained and to hold murder Somidrale. Allahabad High Court, Ashok Kumar, son of Balbhadra versus Assistant General Manager.
I submit, my lord.
I may be submit the judgment along with the memo, my lord.
You do whatever you want to do it before 2 o'clock. Otherwise, we will deliver the judgment. Yes.
My lord, in this case, may I make one submission, my lord? Here, this Honorable Supreme Court, my lord, in the case of report judgment dated in civil appeal number 133. That also, I'll also produce my lord.
No, we will not. This civil appeal number.
I'll produce my lord. My lord, I'll produce. Afternoon, I'll come to the court and produce my lord.
I may be permitted to submit, my lord, in the afternoon.
Not afternoon. Before 2 o'clock, you should do whatever you want.
I appear for the appellant, my lord.
I appear for respondent in this case, my lord.
Yes. We will hear you tomorrow. Tomorrow, ready?
I am ready, my lord.
Tomorrow.
Tomorrow. Tomorrow.
Tomorrow. I am ready, my lord. Tomorrow.
List tomorrow, madam. 36 list tomorrow. 37.
37, CTP Mutana.
My lord, in this.
Yes.
My lord, in this case, my lord, this is only small issue involved, my lord.
You are ready.
I am ready, my lord. Only one small issue, my lord. Here, that punishment of stoppage of 2 increment for 4 years has been imposed, my lord. And that learned CJ has no jurisdiction.
Tomorrow, Mr. Counsel.
Yes,
tomorrow, Mr. Mutanna, tomorrow.
Tomorrow, yes, my lord.
Number 38, Sri Gurumurthy Yan, Sri Shanti Bhushan, Sri KV Arvind.
One memo.
Each side. Yes. Learned counsel. That's why. Please argue on the next day. Today you have benefit of time, right? We don't have time. That's a praise for it. No means what? We don't want to argue. All we are saying is that please argue on the next day. You should say yes. If you don't want to argue, tell us that you don't want to argue. We will discuss it today itself. Why? Oh, so you should tell us, no? You sought time in the beginning.
Where of subsection 148.
In this repetition, notification. No, what is this notification? Which page? Petitioner has received the value of the notification dated 31st March 2021 issued under section 3 within bracket 1 of the taxation and other laws within bracket relaxation and amendment of certain provisions bracket code act 2020. In view of purposes submission, let the petition be discussed before appropriate bench.
First our matter, number 15. Correspondent.
We will hear you tomorrow. Tomorrow. Yes, tomorrow. Which case? 15. 15. This tomorrow.
Number 32. The Karnataka city.
Even when the last stage, even when the matter is taken up in second of
Paucity of time due to paucity of time. Due to paucity of time
Here for the petitioner, even when the matter is called in second round, awaiting the appearance of learned counsel for the petitioner, hearing of the petition is deferred this next week. Many cases repeat in our family.
My lord, may I make a submission for serial number 46, my lord?
Will be repeated tomorrow.
Please, my lord, interim order may be extended.
No, tomorrow it will come back. Which case 40, 46.
I appear for the petitioners, my lord.
Fine.
Interim order may be extended, my lord.
Very important. What's your name?
Shivabhushan, my lord.
Huh?
Shivabhushan, my lord.
Learned counsel for the petitioner. Ms. Mayan Tara BG, learned counsel for respondent 1 to 16. Why do you want time? Learned counsel petitioner prays for adjournment. List of respondents 1 to 16. Prays for adjournment. Interim order granted on earlier occasion for continuous administrative appearance. List after 2 weeks.
Grateful, my lord.
Ah. 49 this day after tomorrow. Ah. What? Okay. This on 42. This on 10th of February 20.
My people are mentioning. So many people are there here.
You're gone.